For the next session, we're going to go all the way, we're going to go by video to Washington, and where FTC Commissioner Melissa Holyoak is sitting with someone who served on the FTC with her, my partner, Christine Wilson, from 2018 to 2023. So this is, Christine, this is a great opportunity to see someone who's been advising our clients for the last couple of years, or the last year, on trying to navigate the US regulatory antitrust landscape, and has tremendous insights. She knows obviously Melissa and Andrew Ferguson and Gail Slater well. There they are. And to be able to have her as someone from the outside, but also who has been on the inside for so long, sitting there with Melissa, I think this is a real treat. I wish they could have been here in person, but the only way to get them was because they're doing so many things in Washington right now that we had to do it by video. So let me turn it over and have the great Christine Wilson, formerly of the FTC, and Melissa Holyoak, currently FTC commissioner. So two FTC commissioners in that sense talking. All right, take it away, guys.
Thank you so much. We are, as Ethan said, beaming in from Washington, D.C., where Melissa has several events this week, as do I.
Christine, for joining. Thank you very much, Commissioner Holyoak. So I'm Stavros Gadinis. I'm a professor at Berkeley Law School. My primary areas of research are corporate governance and company efforts to self-regulate. And I'm very happy today to have the honor to talk to Melissa Holyoak, the FTC Commissioner. Before joining the Commission, Melissa served as Solicitor General with the Utah Attorney General's Office, where her duties included supervising antitrust and data privacy divisions. And before taking on that role, she served as President and General Counsel of the Hamilton Lincoln Law Institute, a Washington, D.C.-based public interest law firm, and in other public interest attorney positions with the Competitive Enterprise Institute and the Center for Class Action Fairness. Thank you very much for joining us, Melissa. And it was also a pleasure to get to meet Christine Wilson. As Ethan mentioned, Christine is the head of US Antitrust, Competition, and Trade at Freshfields. And prior to Freshfields, Christine had completed, as she told me in the prep calls, 3 tours of duty at the FTC, starting all the way from law clerk to commissioner, a role that she left in 2023. Her prior practice includes stints at client practice as well as an in-house lawyer, so she understands the perspective of every single person in that room very well. So let me kick us off by asking, I would say, the obvious question that you don't actually need to be a professor to ask. How is merger enforcement going to be different under the Trump administration compared to the Biden administration? What kind of differences can we expect? Will we see a return to grounding merger review in precedent and sound economic analysis?
Well, thank you, and thank you for that question. Can you see us all right?
Yes, we can see you fine.
Okay, great.
There is some shading going on, but I'm not sure about that.
How about now? Well, good. We'll try and avoid that, or I'll try and stay a little bit still, so that doesn't impact things. So thank you so much for that question. I will start by saying that the views I expressed today are my own. They do not necessarily represent those of the Commission or of any other commissioner. But I'm happy to start to jump into that first question, which is about how will merger enforcement be different. And I think it will be very different. I do think the previous administration, they had a hostility towards mergers, just generally. And I think that showed up and was manifested in sort of a number of ways. One of which was really the cases they brought. So, for example, some of these novel theories that were not very successful, and thinking of the meta within the Activision case, and some of them where I think they really push the boundaries in terms of the rule of law, Exxon and Chevron, those consent decrees. And so I think we will see a difference in approach there. I have supported merger enforcement on a number of times in the past year, particularly on traditional theories. And I'm not shy about telling folks that I will be aggressive when it comes to merger enforcement. But my general approach is, and I've talked about this in the past, that it really should be this like three-legged stool of antitrust litigation, which is we're going to have a strong case. We have to be looking at the documents, the testimony, and the economics, and that together, based on the precedent, approaching those cases, making sure that we have a really strong case as we proceed in litigation.
So, as you mentioned, Chair Khan really did believe that all mergers were bad. And because of that, she sought to increase the time, the risk, and the expense to do deals because she just wanted to chill all merger activity. And she used what I call gently procedural shenanigans and basically using every procedural lever available to chill M&A activity. And I'm wondering whether there were practices that you found particularly egregious, or and can we trust that the Trump administration is going to play it straight and look at cases on the merits?
Mm-hmm. And I would say, in terms of procedural shenanigans or just procedural a disregard for procedural norms, I think I would just identify a lack of communication with the parties, a lack of transparency, which I'm confident and is a priority of mine to make sure we bring that back to the merger review process, that we're talking to folks, that we're having those communications early, that they understand the legal theories and the thoughts and economic theories that we're trying to push forward, so they get where we're coming from. We can have those conversations early and upfront. I think there's a number of ways that we can improve and return to sort of normal process and improve the process. One that comes to mind is early termination. That was removed and has come back. It hasn't come back quite in full force, and I think some of it is we're not getting the requests that we once did. Mm-hmm. I don't know if folks are gun shy, but I do encourage people, this is a request that needs to come to us. So encourage folks that they do make those requests so that we can hopefully honor them and be able to grant those and be able to move forward. I think that can be very beneficial to both the parties so that they can move forward with their transaction. I think, as you know, 98% of the mergers that are filed with us, they don't get a second request. So these are a lot of transactions that can move forward. So that can be really beneficial to the parties, be able to close and provide the benefits to consumers and that redound to consumers and proceed with those. But also, it's really helpful for staff. We want to get rid of, let's clean up their docket. Let's get things moving and going. So I think that can be one thing. I also think just generally, as we move forward with as we're reviewing mergers, maybe we need a little bit more time to look at something. What kinds of things are available to us in terms of off ramps and quick looks? Are we engaging in that, or are we, which the previous administration, are we requiring substantial compliance with everything? Is that necessary? And so I think we should be really exploring all of those options to make sure that we are we can return to a friendlier review process and making sure that I think it's critical in that regard to have a much more predictable environment for the parties who are trying to go through that.
I think you're being very kind to the previous administration by not listing all of the very egregious procedural shenanigans, but I will follow your lead and be gracious, and we'll just let it go.
We're going to turn the page and have a good.
We're going to look forward.
Yes, look forward.
Look forward. So you mentioned off ramps, and one of the potential off ramps is remedies, right? And there are deals where it is very clear there's an overlap, where there's a concern, there is a remedy to be had. And under Biden, remedies were not available to the parties, except sort of under the radar in ways that I think actually didn't necessarily procure benefits for consumers. And so there was this interesting trend beginning with, I think, Commissioner Rohit Chopra, who was my colleague, who basically said all merger remedies are going to be insufficient. They will not be able to restore the competition otherwise lost by the merger. He decried remedies that had been spectacular failures in the past. And let me say, there are a handful of instances where merger remedies did not succeed. But I know that FTC staff works very hard, so does DOJ staff, to design remedies that will succeed. And so we know that they work because there are lots of retrospectives that have been done, and those show that in fact remedies have worked. And so you've mentioned that remedies are back on the table, but I was wondering if you could describe for us, I think the bar for remedies has permanently been raised. I'm wondering if you can describe what you are looking for in a remedy to assure you that it will be sufficient, and are there certain types of remedies that parties shouldn't even consider?
I'll start with the first one, which is no, I don't think there should be any remedy that we shouldn't consider. I think bring everything to the table. If we don't think it's going to be sufficient, if we don't think it'll work, if we're not satisfied with what's coming in front of us, then we'll go to court. And we should really be considering those divestitures, or I should say, when we're talking about structural remedies, in situations where we really think that we could get a fix for the harm that we perceive, and that it could proceed on a pro-competitive basis. And if we really don't think it's going to be successful, then let's go to court and let's challenge it, and bringing it in those cases, utilizing it in those cases where we do think where we have those grave concerns. I think there's a number of things. Stepping back on the retrospectives, I think the question comes up in whether there should be a higher standard or not. We need to move forward with it, but the question really is restoring what's lost. I think sometimes when we're looking at the market, we're not central planners. We're not out there to look at the market and say, okay, well, this market would work best and be the most competitive if it had X, Y, and Z, this number of competitors, and if this one was, reacted or behaved this way. And that's not our job, nor could we ever do that. I don't think that's appropriate. But what we want to look at is what is lost, and how can we restore that? Obviously, it's very challenging. If we are looking at, for example, like a structural remedy, we're looking at likely an area that might be consolidated. And so might be challenging, as buyers come forward, as potential divestiture buyers come forward, are we creating new problems? But let's look at it from a perspective of what might be lost and how do we restore what is lost, not trying to achieve an absolute perfect competitive market in our minds of what we would love if we were designing that market, but just trying to fix that. And then at the same time, as you're looking at these retrospectives, I think it's also, we have to keep in mind that we might restore that competition, but that doesn't ensure what's going to happen to those companies down the road. We don't know if poor management or some other decision or some maybe great innovation from one company is going to make them outperform another one. And so that all needs to be kept in mind as the competition may be restored, but then as future performance moves on, keeping that perspective in mind as we're trying to assess whether something was successful or not. But yes, let's keep doing those retrospectives, and I am absolutely supportive of that. Mary Beth in our compliance
is amazing.
She's amazing. She's fantastic, and I think she does an excellent job in understanding the issues and really identifying some of the potential problems and solutions that we may want to consider. So I would absolutely consider the structural remedies that come forward. behavioral also on the table, can be a little bit more difficult as we assess compliance costs and framing exactly what's going to happen. And if I sometimes those are more difficult in terms of trying to understand whether it will fix whatever issue we think maybe that we're trying to address.
So maybe a little more difficult to sort of memorialize commitments and then monitor and enforce when you have lots of moving pieces for a behavioral remedy.
Mm-hmm. And also it's almost 4D chess in terms of like trying to understand, I think, will this impact this behavior or do we anticipate other behaviors that could have similar anti-competitive effects?
So first of all, I just got to say it's so refreshing to hear an official at the FTC say, we're not trying to be central planners. I love that. Professor, back to you.
So I wanted to ask you a little bit about issues that are of particular interest to our audience in the Bay Area. And I saw a recent speech you wrote about innovation, startups, and merger enforcement in that space. So that was something that was really distinct about merger policy under President Biden, which was startups could mostly were expected to expand organically or via an IPO. So now I wanted to ask, are we going to see a change in that approach, and how will the acquisition of startups be examined under President Trump?
Absolutely. That's such a great question. And I really think the ability for startup to create itself and have in its plan as it's creating itself the option to get purchased by some other company, it needs to remain a viable plan for folks. It's so important. Is there a scenario or is there a world where a large company could be trying to take up some small, very innovative company and just strangle it in its cradle and trying to kill that innovation because they're concerned about that competition? Sure, there could be. Very difficult cases, extremely difficult. But with that in mind, we cannot foreclose the ability for startups to have the option of being purchased and only have organic growth or IPOs. And there is nothing in the antitrust laws that favor that one over the other. There just really is not. And I think that sort of myth needs to be put to bed. I think particularly with IPOs, just last year, there were only 55 IPOs. So putting that in perspective and thinking about all of the technology and emerging technologies and emerging markets out there, it is just not possible. We would have innovation just come to a total standstill, because for a lot of these startups innovation, that investment, that capital is just going to go away if they don't have that option. So we need to maintain that option for folks and not approach things from such a strong draconian enforcement measures that will kill that viable business model.
So an area where there's a lot of startup.
I'm sorry, go ahead.
Sorry, go ahead. No. I wanted to ask a follow-up about AI, but we can move on to the next question if you'd like.
Yeah, let's.
But first, say what
I was just going to. You and I have talked about this, right? Yeah. And some of the saddest stories that I have heard, but also some of the most heartening stories, deal with actually young women in the tech space who have talked to me about serial innovation. And they have created companies and sold them and started new companies. And there was one great story I heard right after I left the commission. And she was this young woman who had come from a third world country. She had launched a startup and she had sold it and then launched another company. And she was just so thrilled that someone understood the importance of that off-ramp and being able to be purchased so that you can get the cash and then start a new company. And so I think it's really a breath of fresh air to hear the change in perspective.
Absolutely. It's a great American tradition, right? And we should be celebrating these innovators. There are people that are just born innovators. They just want to create, but they want to keep creating new products and not just stay at that one place and try and grow it organically for the rest of their lives. And we shouldn't be stopping them from that. And we should actually be encouraging it, because what comes from that is just some of the greatest innovation.
So let's pivot. In recent weeks, we have seen the FTC issue for comment proposals to modify consent decrees that were finalized under Biden. And so one of those was the 2017 final consent order relating to Enbridge's merger with Spectra Energy. But sort of more relevant for you, there were two mergers in which you dissented, Chevron Hess and ExxonMobil Pioneer, and you were unhappy with those consents, and those petitions to modify those consents have now been put out for public comment. So can you talk a little bit about why the commission is considering modifying those, and then and maybe you can't talk about that specifically, but if not, what are you looking for? What is the commission looking for in terms of petitions to modify? What are the standards that need to be hit, and what merits being modified?
No, absolutely, great question. I guess I'll start with, let me just step back and talk a little bit about Exxon and Chevron and my concerns with that, so folks understand what was happening there. So Exxon and Chevron were both oil and gas mergers that came to us. Both involved very large companies, Exxon and Chevron, and very smaller companies. And what the FTC was very focused on was the two individuals that ran these smaller companies. And in both instances, they focused on some of the communications those gentlemen have had, and believed that they were it was collusive behavior, and they were concerned about elevating those gentlemen to the boards of the future respective companies, Exxon and Chevron. And I dissented from those on a number of grounds, but what I really focused on was the fact that those communications and all of that had nothing to do with, and elevating these folks to the board had nothing to do with the question that we had to answer, which was that merger going to substantially lessen competition? And the answer was absolutely no. And so I was very concerned about the overreach here, the complete disregard for the rule of law, because we were imposing a consent agreement on these folks just based on our merger enforcement and extorting that type of consent agreement, leveraging that authority to be able to pull that consent agreement.
And maybe for political reasons, not necessarily for any substantive reasons.
I mean, and I've talked about this openly. I mean, there's no question there was a letter that came from 23 senators telling the FTC you need to do something. So the FTC found their scapegoats there. And it included those two gentlemen, Scott Sheffield and John Hesse, in those orders, and prohibiting them from serving on the boards. And so I dissented from that quite strenuously, and sort of put forth my concerns in my dissent. Going to Enbridge. So Enbridge, I just supported that change, and there was in that we had an agreement with them where they had some interest in a rival pipeline, and what the agreement required them to kind of put up a firewall of sensitive information because of those interests in the rival pipelines. And when that interest in one of the rivals was gone, it made no sense to keep that requirement there. And the question, the standard that we're looking at when we're looking at whether to make these changes is under Rule 2.51. We look to see whether there are changed conditions of fact or law. And so in this case, there was a changed condition of fact. But there's another portion of that standard, which is whether it's in the public interest. And I'm not going to speak to whether Exxon and Chevron, whether those should be changed. I think my views on those orders are pretty well known, but as to whether they should meet the standards or whatnot, I won't speak to. But I will just just explain what we're looking for. In addition to that changed conditions of fact or law, it is whether that public interest standard, and whether it's in the public interest to make those changes. And part of that, what the FTC cases have looked at in the past, is sort of this cost-benefit analysis and looking to whether the imposition of complying with that outweighs the benefits to the consumers. So that is what we need to be looking at and analyzing as we go forward with some of these requests.
So I'm not going to ask you to opine, but just note that there were instances under the Biden administration where consents contained prior notice and prior approval obligations on parties so that they would have to go above and beyond HSR obligations for future deals, which would impose additional burdens on them, but also on the agency. And I think those might also be an opportunity for petitions to modify, given the burdens imposed and not necessarily the benefits if those provisions were imposed in a punitive way. And I think some of those were purely punitive.
I think there certainly could be instances. I think it would be very factually dependent.
Absolutely.
And understanding why that requirement was put in place, understanding the circumstances surrounding whatever the murder or the matter was. And so I would look at those very carefully.
Professor.
So we have about 3 more minutes. So I wanted to ask you to move from big oil to big tech, so to speak. So a lot of our conversation today has focused on areas of difference between the Trump administration and the Biden administration, but there are some issues where there is more of an alignment. And one of that issue might be the FTC's approach towards big technology companies, a question that's on everyone's mind here in the audience, not only because we're in Silicon Valley, but also because it's been on the news lately a lot. So I know that obviously you can't comment on ongoing cases, but I'd like to invite you to share some general thoughts about how the FTC sees that area.
Oh, it's an excellent question. And I should note that many of these big tech cases started under Trump's first administration, proceeded through Biden, and are continuing and just getting an answer to some of those questions now. So I do think there is, common interest going across the administrations on those cases. But I think just stepping back, I think some of the reason why is because these companies, they're enormous. They operate at a scale that we've never seen in history. And so, of course, we're going to be very interested because they have such an impact on nearly every aspect of our lives and nearly every American in terms of interacting with them. So we will, of course, be very interested and will remain very interested in big tech and what's happening. And I will say an additional reason is because we're seeing many of these companies are very involved in the development of AI. And that's another, that nascent industry is something that we're obviously very interested in. We want to remain absolutely vigilant in understanding how that industry and how the technologies are developing and understand if there's any issues there. And so we will keep a very close eye on all of that. I just recently supported our 6B report on AI, and it really looked at some of the investments, the relationships between these companies, but also was really trying to describe, and helpful for the public in understanding like every kind of aspect of the stack and what we should be looking for and how we should be thinking about these issues.
So one last question. Obviously tech, huge focus. Are there other industries that will also be scrutinized very closely? Obviously, there is no such thing as a de minimis exception to competition. You're going to look at all the mergers closely, but are there particular areas where you're going to look even more closely?
And I think that's great question. And I think those that are impacting Americans the most, we will continue to look in the healthcare industry. I think that is of great concern to Americans, in addition to the big tech. I also think just generally what's on my mind right now is just maybe general consumer retail and things. We've seen, obviously with inflation and discussions of increased pricing, something we're concerned with. And Chairman Ferguson has talked about this. I think he was unfairly characterized as telling people to not raise their prices, and that is not what I understood him to be saying, and I share his concern, and the concern is when you're at a moment in time like ours where you may anticipate certain price increases, that is an opportune moment for folks to get together and say, well, okay, well, let's see how we're going to raise these prices and where they should be, and other anti-competitive behavior. So it's not that we're telling folks you can't do this X, Y, or Z. It's we are going to be absolutely vigilant in looking at these issues and understanding, is there anti-competitive behavior in connection with some of these issues.
Thank you so much. Thank you.
Okay, great.
Professor?
Thank you very much, Commissioner, for being here. Thank you very much, Christine, for leading the conversation. Thank you both.
Thank you.
Take care, everybody.